Hello, friends. We welcome you to the Legal Breeze. Today, we are taking a new initiative for the benefit of our legal fraternity because with effect from 1st July of this year, the new laws pertaining to Indian evidence, CRPC, and IPC comes into effect with the new names called Sangeetas and Sakshi Abhinayams, one may call it. Now, in this video, we are going to analyze or compare provisions relating to search and seizure, which is existing under the CRPC 1970s and the Bharatiya Nagarik Suraksha Sanhita, hereinafter called as Sanhita 2023. Now, what are all the similarities, differences? All these things will be covered. CRPC Chapter 7 deals with search and seizure. It has also inserted a new chapter called Chapter 7A. So, therefore, it roughly starts from Section 91 and ends at 105 and 105B of the CRPC. On the other hand, this Sangeeta provisions relating to search and seizure somewhere else starts from Section 94 and ends at approximately around Section 110 and 111. So, this is the small differences. One may believe that Sangeeta has made substantial changes relating to provision of search and seizure. That is not the case. Almost 99% it retains the provisions, each and every provisions, without even changing a single letter of the existing provisions. Just it has simply renumbered the sections. That's it. But however, one cannot say so that there is nothing new at all. There are certain things which is new, but it is not substantially new. It has not made any substantial changes. It is only has made certain superficial changes, or it has not made any huge significant changes. That's it. For example, in the old act, that is CRPC, the police officer is empowered to sell the property which is less than value of 500 rupees subject to certain conditions when it is seized during the search and seizure proceedings. The same 500 rupees is retained even in the Sangeeta. Today 500 rupees is nothing. At least they could have raised this to 1000 rupees. Next example, one may quote it. Procedures dealing with letters and telegrams and etc. We all of us know now the telegram services itself has been totally abolished way back just few years ago. Now, this Sangeeta has not even taken into account that the abolition of telegram services. It uses the same verbatically whatever it was there in the CRPC. Again, it uses the postal authority, custody of postal authority and telegraph authority. We don't have any objection to that. Of course, recently the Post Act has also been passed, new act. Currently, we don't go into those things. But courier services and other app-based delivery services relating to parcel, documents and other things have come up. That could have been addressed in the new Sangeeta. However, Sangeeta miserably fails to do so. It simply reproduces whatever it is there in the CRPC. This is a deeply regrettable one. Then what is the advantages of Sangeeta? Sangeeta has made few advantages or few developments. In section 94, the word document, it says the document includes all the electronic communications and it digital evidence and electronic devices. These are all the three words used. However, none of them have been defined under Sangita, to the best of my knowledge, at least in this chapter is concerned. So the vagueness and ambiguity relating to this term shall be avoided. So therefore, it should be properly defined. This is one. Two, after seizure of all these electronic devices, digital evidences, all these things, it can be manipulated. It can be tampered by the police or other persons when it is put in their custodies. We all know when the EVMs are kept in the custody of election commission, huge security arrangements are made so that it is not being tampered or manipulated. So what happens to these electronic devices or gadgets are tampered or manipulated? So there is no such safeguards. Such safeguards should have been made available before authorizing these officers to collect all these things. This is, though it is welcomeable one, but these changes are to be incorporated in the Sangita. This will affect the entire right to privacy and other fundamental rights. So its constitutional validity is doubted. The best story, all of you know that the Bhima Karehon case, where one of the electronic gadget, one of the mobile of the so-called accused has been seized by the police, and when it was sent to the forensic report, it was proved by an American firm that through a technology called RAT, remote access trojan, certain files have been placed in his mobile, the accused mobile, by someone else without his knowledge, and based on that file only that person was arrested. So that's a very sorry state of affairs. When we have these sort of live examples, the issue of Pegasus, the court, parliament should have made, parliament should have applied its mind, the drafters should have applied their mind in introducing powers or authorizing powers to the police officers to collect the electronic communications, electronic devices, and digital evidences. We don't object the collection of the same, but there shall be certain safeguards. That's what we strongly suggest. The next one, what we welcome is that in the previous CRPC, only upon an oath made by the abducted women or female child, certain steps can be taken to restore them back to their family. Now, it made a small change. Upon a complaint or oath made by the victims, this process can be initiated. Now, the complaint can be made by Women Commission or POXO, under the POXO Act. There are many other mechanisms have come up. So this is a welcomeable change, though it's a small one, but it makes a fundamental change in protecting the rights, particularly trafficked victims, particularly female children and women is concerned. This is a welcomeable change. Next one, this is very important. Under section 105, the entire search and seizure has been mandated to be recorded. Audio, video recording has been mandated. It has to be done by the person who is carrying out the search and seizure. And they say preferably through the cell phone. And after it is recorded, it has to be immediately sent to the district magistrate or subdivisional magistrate or judicial magistrate. Though it is welcomeable one, but it has to be clearly laid down. Is it the priority? Is it based on the order, the priority, or it shall be sent to simultaneously to all these functionaries such as DM, SDM, and the JM, that is judicial magistrate of first class. This needs to be clarified. This is very important, so that certain independent, certain transparency is maintained during the search and seizure is concerned. This is very important. This is a welcomeable change. Next one is very important. attachment relating to the proceeds of crime are people who are indulging in smuggling, money laundering, and other things. When it is being seized, those properties have been seized. The concerned police officer has to report to SP, and SP has to make an application before the competent court. If the competent court convinces it is a proceeds arising out of crime, uh, then the court will attach the same, subject to certain formalities such as issuing notice and other things. Provided the person fails to appear before the notice or appear before the court or fails to respond to the notice, uh, um, the court can very well go for an ex parte order. And not only that, it goes one step further. The court can give direction to the district magistrate to distribute the proceeds of crime arising out of certain properties, or properties gained by criminal activities, shall be distributed to the victims or claimants, and if anything remains thereafter, shall be credited back to the government. In case if the claimants are not able to be identified, the entire property stands forfeited and credited to the government account. This is, though it is very drastic, but this is a totally a new law. I believe this was introduced during the Fugitive Offenders Act when Arun Jaitley was there. So these changes have been accommodated in the new Sanghita is concerned. Uh, Proceeds of crime, property has been defined under section 111 of the Sanghita is concerned. This is dealing with money laundering offences, smuggling, and other things. So this is a welcomeable one. So by and large, our criticism is that almost 98%, 99%, the new Sangeeta carries verbatically the old CRPC. It has simply renumbered certain sections. Here and there, it has made certain changes, such as incorporating technology such as ICT, video audio recordings, and to some extent addresses the rights of the victims. So these are all the welcomeable changes. We hope it is useful to you, all the members of our legal fraternity. Please do use this information positively, and please let us know your comments. Thank you all. God bless you. Jai Hind.